Now, as promised last week when we reported on the legal tussle between the Advertising Standards Authority and the slimming product Herbex, we've extended an invitation to get the industry watchdog's take on the Supreme Court of Appeal's finding that the ASA has no legal authority over non-members. Now, this follows a long-standing row between the ASA and this product Herbex that was taken to task over claims that it made, but eventually won once the case went to the higher court. Gail Schimmel is the Chief Executive Officer of the Advertising Standards Authority. This has been a long battle. Gail, first of all, before we get to it, remind me again of the purpose of the ASA. What do you do?
In essence, the ASA is a consumer protection body. At its heart, it is a consumer protection body. We are the people you complain to if you believe that something in an ad is misleading, untrue, offensive, racist, any of those issues. We are the body that you complain to, and we are then a neutral forum that makes a decision about it.
And for members of the public, there is no charge?
There is no charge for members of the public.
And how then are complaints adjudicated?
So we receive a complaint, there then is a process, and it's quite important to say this, we then determine whether or not we have jurisdiction, and we also determine whether or not there's a prima facie complaint. So we're often criticised for taking any old complaint. We don't. We weed out the real nonsense. If you think that the things you're seeing are nonsense, you should see the other things on our plate. So we weed them out, and then we give the advertiser right of response. And we make a decision. That first decision is made by full-time staff members, at the moment all lawyers, who make a decision on the papers. There are then two further levels of appeal. If the parties are not happy, they can appeal. What
then was the genesis of the Herbex complaint?
So the Herbex complaint stemmed from, like every complaint we have, a complaint from a consumer activist in this case, Dr. Steinman, who complained that the claims were not true for the Herbex product.
And this went through the adjudication process. What was the eventual decision from the authority?
Eventually we found that they hadn't substantiated their claims.
But having said that, though, Herbex predictably wasn't happy about this. They then sought a different type of legal recourse. What happened?
So they then took it to court, and they took it to the High Court, and their whole cause of action was that they said that the ASA cannot rule against non-members. Now, from the start, the ASA has never held out to rule against non-members. The ASA is a creature of contract, and our relationship with our members says to our members that we will rule against and on our members' advertising, but also for our media members, we will make a decision so that our media members know what to do with advertising that there have been complaints against. Herbex said that the ASA has no right to rule on a non-member, and they took us to court. At the High Court level, the court agreed with them and said that we could not consider the advertising of a non-member. We then took that on appeal, and the Supreme Court of Appeal accepted a consent order saying that we have no jurisdiction over non-members. So you place an ad. I cannot tell you what to do. But what I can do is consider your ad, if we get a complaint, and tell my members what to do with that ad. So Herbex was quite right that we have no jurisdiction over the non-member, but we have jurisdiction over the non-member's advertising.
I'm a little confused when you talk about members. These would be brands that pay up and subscribe to your particular code.
At the moment, it's an indirect membership. So at the moment, they would be members of member organizations. The other thing, to be very clear, 90% of brands listen to the ASA whether or not they're members. So most of the things you see advertised, if we say to them, pull your ad, they will happily pull their ad, either because they're members or because they recognize that self-regulation is the right thing.
And the consequences of not pulling the ad could be detrimental to the health and the equity of the brand itself.
Of the brand, and also eventually, if you play it out to the end, if the ASA is not there, if the ASA does not work, government will intervene.
It does raise useful questions, though, about the power and influence and authority of the ASA itself, given that you've had one brand who has now challenged you head on and has taken it to the highest court in the land. So in other words, does something need to change fundamentally as a result of that? Because the sense is that this might create some sort of precedent where brands say, well, if it worked for Herbex, why do I need to listen to you?
From our point of view, we won this matter. So from our point of view, the precedent is a very good one, because it says that we can make a decision about a non-member's advertising, and we can go to our media members, and remember, particularly the broadcasters, in terms of the law, have to listen to our decisions. So we can go to our members and say, this is what we have decided about this piece of advertising, and they will then no longer run that piece of advertising. Remember at the beginning I said our main aim
They
is consumer
choose no
protection.
longer to run that advertising. They're not compelled
The
to.
broadcasters are compelled
They
to.
are compelled to.
They are compelled to.
And the print media?
The print media are not compelled to. They choose to through their relationship with us. Their relationship with us at the moment is a little bit more informal than it used to be, but our experience is showing they are still abiding by the ASA rulings.
So where does this leave a brand like Herbex then? Is it able to continue going rogue with its advertising if it so
Well, in
chooses?
fact, we're in the new chapter of Herbex. So as soon as this Supreme Court of Appeal decision came, we got a new complaint from the same complainant against a Herbex ad. One of the things is we not only are allowed to consider that advertising, we have to consider that advertising. If we get a complaint against a piece of advertising that falls in our jurisdiction, we have to consider it for the guidance of our members. In that matter, Herbex chose not to respond, so we didn't have any substantiation before us. We don't know. They may hold the most fabulous substantiation that their products work. We don't know that. They didn't show it to us. And we therefore had no choice but to say there's nothing before us. We therefore presume it was a testimonial, that this testimonial is not true, and order the withdrawal of that ad.
Gail Schimmel, Chief Executive of the Advertising Standards Authority of South Africa, thank you very much indeed.
Thank
You can weigh in on this particular story and others on our social media platforms. Until next time, goodbye to you and thank you for watching.